WEFM, the new fresh sound.
Rise and shine. Let's get ready to take on the day. Activated Mornings on WEFM 99.9 is on now.
Welcome back, St. Vincent and the Grenadines. The time is now 7:45, and we're into our second segment here on Activated Mornings this morning. In case you're just joining us, we just came from the topic. Sandals announced its partnership with local artisan businesses. And in wrapping up that topic, just like to say, I don't see how it's something negative, but I am curious about what the selection process is like, who is left out, who has decided that they're going to participate when these expos are happening, or whether or not each business is going to have an allotted time or at least a chance to showcase down at the resort, because it obviously is only going to be a positive thing for those businesses. It's going to mean exposure, it's going to mean possible collaboration, it's going to mean networking. So shout out to Invest SVG and Sandals for this initiative, and I do look forward to the businesses reaching further in their business careers. Now, moving on to something totally different, in a totally different realm. We have the cybercrime ruling from earlier this year, where someone was, well, the name is here on Eyewitness News, Rishon James, was sentenced to paying $6,000 in a civil matter. And since then, a lot of lawyers have been questioning the ruling, saying that the court had no jurisdiction to hear the lawsuit. But we'll go into it a bit deeper this morning. Now, Eyewitness News has a lengthy story here published last night. The headline is Historic Cybercrime Ruling Under Scrutiny. Lawyers say court had no jurisdiction to hear the lawsuit over boyfriend accessing woman's phone. So the court ruling in the historic civil lawsuit brought under the Cybercrime Act, which has no civil jurisdiction, has come under scrutiny, with lawyers saying it should be appealed and not allowed to stand. Lawyer Adrian Udo brought the case on behalf of his client, Sophie Lawrence, who alleged that her ex-boyfriend, Rishon James, had trespassed into her home and accessed her phone illegally after snatching it from her through a window and running away. When the matter was heard at the Connery Magistrates Court on January 18th, Udo commented that it was the first matter heard before the court under the law that was passed in 2016. Magistrate Bertie Pompey agreed that that was so. Udo welcomed the ruling, in which Pompey, after a trial heard in James's absence, ordered that he pay Lawrence $6,000 in damages for illegally accessing her phone and issue $100 compensation for trespassing. However, a lawyer has since expressed to Eyewitness News concerns about what transpired in court and Udo's response to issues raised when he spoke about it. When he spoke about the Cybercrime Act during an interactive radio program on January 25th, that is WEFM'S Cop Chat on Activated Mornings. There is, in fact, no civil jurisdiction under the Cybercrime Act, and it is my opinion that the magistrate had no authority to hear the matter as it was brought before him, the lawyer told Eyewitness News. The lawyer said it would be inappropriate, in light of our employment and circumstances, to speak about the matter publicly, but also because doing so would put the court under scrutiny. They were clearly wrong to entertain the claim, the lawyer told Eyewitness News, referring to the court. So the story went on to speak about the matter being tried in the absence of the defendant, which is fine. The claimant seeks $14,000 in compensation. Udo saying that he hopes this sends a message to young men illegally accessing the cell phones of females. And when he was, in fact, on Cop Chat here on Activated Mornings, he did mention that we have to see how it plays out, and no attorney is perfect. But Roleza, you were here when when this happened. What are your thoughts?
All right, so it's not so much a matter of what my thoughts are in relation to the conversation that occurred on during the cop chat segment. I think what it is that I have to question at this time is, yes, the questions that we raised. I see that the lawyer is saying the same thing in terms of there would have been no jurisdiction. In speaking with several lawyers, they have the same opinion as that particular lawyer, right? And it was the same question that we would have asked here in terms of a criminal act. How could it have been tried, at least in the first instance, within civil court? However, subsequent to that conversation, in speaking with someone else, they were indicating that what took place can happen, right? So for me, with my non-legal brain at this point in time, I just need for somebody to come out and speak on the matter, because yes, I know within law that there may be a difference of opinions, difference of interpretation of what can happen, right? But I think given the publicity that surrounded this particular case, when it came to the public's attention, persons were there thinking that, okay, so yes, now going forward, that they too can bring a civil case against someone in the first instance, not necessarily having to go through criminal proceedings first and take it up in a civil matter. I think for me as a layperson, and the thing of it is that I did try to see if I can get someone in a particular position of authority, a lawyer that is, to speak on it. But what it is that I was getting was that a lot of lawyers did not want to come forward and speak publicly on it, which is the same thing that is happening here, in that a lawyer spoke with the reporter for Eyewitness News, which would be Kenton, but they haven't come forward in terms of being able to say, well, I, Roleza Samuel, lawyer, whatever, I'm speaking on this particular matter. It just seems as if several lawyers have been hiding behind it, and I don't know why. And the thing of it is, for us as a public, we need to know exactly what is the correct procedure, what exactly should happen, or what can happen in cases such as these. Because, as I said, when the judgment was passed, it was all over social media, and I tend to think that when matters are all over social media and there are questions that come into play, we already have a vested interest in it, so we need to get some conclusion on the matter.
What I think is, it's very odd. I've only heard two persons. One of them a legal mind, one of them is not a legal mind. And the person that's not a legal mind, I could see why they would lean towards defending what transpired. And the person who was a legal mind, they did say that lawyers can get things wrong, and there is a provision for this to happen. However, this is the only person that I've heard say that, since all of the lawyers that I've spoken to have felt like it doesn't make sense, that the court didn't have jurisdiction, that they were wrong to hear the matter and to hand down sentencing. And a lot of lawyers, whether they do not want to put this court under scrutiny, because of their position, they don't want to say anything on the matter publicly, or I've heard that they simply don't want to embarrass Mr. Udo. But I was confused, because in the beginning, Mr. Udo was reposting stories. He did an interview with Eyewitness News, which is linked to this story. But when he came down to Cop Chat, he indicated that he has no intention of discussing the case because of his client. Now, it's a bit of rocky ground, and it gives me the impression that he believes that he did something wrong, and he was trying to fix the situation by stepping back from it. But the story went on to say that the matter is ripe for appeal and the defendant would win. The lawyer further stated, adding that if the defendant acted as alleged, his action should be condemned and the appropriate legal actions taken, which is the same thing that was echoed here, that if it is that he did do these things, that he's wrong and he should face some sort of consequence for his action legally. But it doesn't seem like this was the right channel. But the story went on to quote the lawyer saying, but justice must be done properly. What he, Udo, has done is have the public think that they can bring a civil action under the Cybercrime Act when they feel violated, when in fact they cannot, not without a fiat or permission from the director of public prosecution for private prosecution. And that is what I understood from the situation, that the DPP needed to give you the power to prosecute this matter because it is a criminal matter. Now, again, interactive program, the number to call is 457-9997. Also, the number to WhatsApp, 457-9997. There are a lot of legal minds that listen to Activated Mornings in the morning, and we really do need some sort of clarity or information on this matter. We need to understand what it is happening, what is going on in this situation, because it's a bit confusing for those of us who are not legal minds in the matter. And it does seem like we're on rocky ground in terms of getting clarity on the matter. Because if majority of the legal minds in St. Vincent feel like something is wrong here, is it that all of them are wrong? All of them got it wrong? All of them are missing something? This is where I myself, this is where I'm very, very, very confused. But I guess the only how we can know what exactly is the proper legal proceeding is when it goes through the Court of Appeal, in which I'm advised that the person will be appealing this matter. I guess that's the only how we can know what exactly is going to happen. Now, another lawyer told Eyewitness News that while the court allows 14 days to appeal a magisterial decision, a party can seek the court's permission to file an appeal out of time. The lawyer said the court is likely to hear such an appeal, especially in light of the view that the magistrate's court did not have jurisdiction in the matter. Now, the story went on to speak about the defendant being tried in his absence. The civil matter was heard in the absence of the defendant, who failed to attend the hearing despite being summoned. A lawyer noted to Eyewitness News that this can happen in a civil matter if there is evidence that the person was served notice of the hearing and if there had been a number of adjournments in the matter. Now, I think I had read that there was a number of adjournments in the matter. But what I'm informed is that the defendant at the time, he's a van driver, and he had another court appearance in Georgetown that day. A traffic offense appearance, and that is where he was at the time of the case. And I have made contact with him, but I don't think it would be wise for him to come on and speak about what exactly transpired, given that the case is more than likely either in the process of being put up to appeal or the process already started of it being appealed. The lawyer, reading back from Eyewitness News, the lawyer said that since the civil suit was purportedly brought under the Cybercrime Act, where the standard on burden of proof and penalty are higher, the court should be satisfied that all reasonable attempts were made to have the person informed of the matter. So once you can prove that the court reached out and tried to get you to come to court and you didn't show up, it could be tried in your absence. Now, the statement of claim filed in the matter said that on September 25th, 2022, James visited Lawrence's home in Connery without her permission and entered her home. Udo said Lawrence asked James several times to leave the premises, but he refused. James asked to borrow Lawrence's cellular phone to make a call, which she obliged. James then took Lawrence's phone and left the residence. On September 26, James took Lawrence's phone to the Connery police station after a police report was made. However, before doing so, he had transferred to another device personally information from Lawrence's social media account and photo gallery, such as explicit photos. As a result, Lawrence sought compensation for trespassing and for illegal access to the cellular phone. Udo said that by a letter dated November 14, 2022, Lawrence demanded compensation in the sum of $15,000, but James failed, refused, or neglected to adhere to the demands or respond. He said his client suffered loss and damages and asked the court to award $14,000 in damages. Now we're getting closer to the hour of 8 o'clock, where we would wrap up this segment. We do have a comment here on WhatsApp, well, in the form of a voice note, if you don't mind.
Good morning, Roleza and Ari. we're having an Indian summer in Bermuda. These past 2 days have been fantastic. I love the idea that Sandals is offering to carry local products. We must bear in mind that this has to be quality stuff made in St. Vincent and not made in China or Taiwan. In any major hotel or resort, there's stores, for example, Skechers, I think it is on Back Street, or Coats. They could purchase items from locals on concession and set up their own store in Sandals. This is not going to be like an area where these Syrian stores. I think the Syrian stores have the cheap items. So it is a good thing. And all craftsmen, because Vincentians are fantastic. I've seen some. My wife has baskets and fans and placemats and all of these things made in St. Vincent and not imported. So this is an opportunity for local businesses to get together, set up a store in Sandals, in the Sandals Resort, and carry high quality, locally made products.
All right, so that was Joshua's contribution in relation to the Sandals topic. And Joshua, I think when you spoke of Skechers, I think you made Voyager. I think it might be called Voyager now. All right, so that is a different matter altogether. But to sum up the conversation that we're having here under the cybercrime ruling under scrutiny, now I know that the legal profession is a fraternity, and maybe this is why persons or lawyers are not necessarily want to come or to be the voice or to be the face of the persons or the ones questioning the ruling, or to state their opinion in terms of whether or not the way in which the matter proceeded was right or wrong. But as I said initially, something has to be said, because for those of us who are within the public realm, yes, it is, we might go to a lawyer and the lawyer is supposed to know better, or the lawyer is supposed to give us the correct advice. But because this has been within the public domain, we would need some clarity on the matter. So I'm not sure if by asking, let's say, the Bar Association to issue a statement, a joint statement, a collective statement on what is the proper procedure, if they can do so. But we just need to know what it is that is supposed to be the correct course of action. So.
And that is really it. The public just needs to know what is right and what is wrong in this situation. But the time is 8:02, soon to be 8:03, and your time check was brought to you by New Haven Funeral Home.